Welcome to Seacoast Real Estate Academy. Today in our Laws and Rules series, we'll be going over drafting, RPOADS, and closing statements. Today we are reviewing a handful of rules and laws covering drafting, reporting criminal convictions, residential property and owners association disclosure statement, as well as broker responsibilities regarding the closing disclosure. Drafting legal instruments. Rule A.0111. This rule prohibits licensees from drafting legal instruments like contracts, deeds of trust, etc., but does allow them to fill in the blanks on pre-printed sales or lease contract forms, which is not construed to be the unauthorized practice of law. Reporting criminal convictions. Rule A.0113. Licensees are required to report to the Commission any criminal convictions for a felony or misdemeanor, any disciplinary action taken against them by any other occupational licensing board, or any restriction, suspension, or revocation of a notarial commission within 60 days of the final judgment or order in the case. This reporting requirement is ongoing in nature. Note that driving while impaired is a misdemeanor and must be reported. Residential Property and Owners Association Disclosure Statement. Rule A.0114. State law, Chapter 47E of the General Statutes, requires that most residential property owners complete a disclosure form to give to prospective purchasers. The form seeks to elicit information about the condition of the property by asking various questions, to which owners may answer yes, no, or no representation. Failure to provide a buyer with this form may allow the buyer to cancel the contract by notifying the seller in writing within 3 calendar days of contract acceptance. Please note, licensees in residential real estate transactions have a duty under GS 47E-8 to inform their clients of the client's rights and obligations under the statute. The Real Estate Commission also views the real estate license law as imposing on licensees working with sellers and buyers certain additional responsibilities to ensure statutory compliance and serve their clients' interests. Licensees are expected to assist sellers with completion of the form, but should not complete the form for a seller or advise a seller as to what representation or no representation to make. That being said, licensees should be certain to advise sellers that the licensee is obligated by law to disclose all material facts about or relating to the seller's property to the prospective buyers, regardless of what representation the seller makes on the disclosure form. Sellers must also provide a mineral and oil and gas mandatory disclosure statement to buyers prior to making an offer to purchase and contract. The form has been developed by the Real Estate Commission and is available for download from the Commission's website, www.ncrec.gov. It is a separate form and is in addition to the Residential Property and Owners Association statement. Broker's responsibility for closing statements. GS 93A-6A14. The cited statute requires a broker, at the time a sales transaction is consummated, to deliver to the broker's client a detailed and accurate closing statement showing the receipt and disbursement of all monies relating to the transaction about which the broker knows or reasonably should know. The statute goes on to provide that if a closing statement is prepared by an attorney or lawful statement agent, a broker may rely on the delivery of that statement, but the broker must review the statement for accuracy and notify all parties to the closing of any errors. Commission Guidelines. A settlement statement is a detailed report of all monies received and disbursed by the settlement agent in connection with a real estate sales transaction. It is essential that the settlement statement be accurate and that a copy be provided to each party. The settlement statement is prepared by the settlement agent the individual conducting the closing, which in North Carolina is almost always the closing attorney or a non-lawyer assistant working under the supervision of the closing attorney. The TRID rule, TILA RESPA Integrated Disclosures, became effective October 3, 2015, and applied to loan applications received on or after October 3, 2015. The TRID rule replaced the HUD-1 Settlement Statement, RESPA, and Final Truth in Lending Statement, TILA, with two closing disclosure documents, one for the borrower and a separate one for the seller. Closing disclosures are disclosures only and are not equivalent to a settlement statement. While the HUD-1 is no longer used in TRID-governed transactions, other types of settlement statements may be used, such as settlement or closing statements created and published by the American Land Title Association, ALTA. Also, the HUD-1 may be used as a settlement statement in non-TRID governed transactions, such as cash transactions, construction loans, or purchases of investment property. The Commission has published in its North Carolina Real Estate Manual the following guidelines regarding brokers' responsibilities for settlement statements. A broker must confirm the accuracy of all entries about which she or he has direct knowledge. Such items include, but may not be limited to, the sale price, the amount of the due diligence fee and earnest money deposit, amount of the brokerage commission and split, any amounts due either party under the offer to purchase and contract, such as closing costs paid by the seller, as well as any sums paid by or due to third parties related to the transaction if the broker knows or should know about the expense. As to amounts paid by or due to third parties, brokers generally may assume that the amounts for charges and fees as stated on the settlement statement are correct unless there is something that would lead to a reasonable broker to suspect that an amount is incorrect. As to all debits and credits related to the transaction, whether paid before or at closing, the broker must: Number 1. Review and confirm that all charges and credits have been properly debited or credited to the seller or buyer and are entered in the correct column. And number 2. Review and confirm the accuracy of the calculations for all prorated items, escrow reserves, interim interest, excise tax, and the bottom line figures, such as total settlement charges to each property, cash from borrower or buyer, and cash to seller. If a broker is aware of any expense related to the transaction paid to or by either party or any third party that is not included on the settlement statement, the broker must notify both the settlement agent and the lender of the omission, as the settlement statement should reflect all expenses and payments related to the transaction, not just monies the settlement agent disburses. A broker should notify the settlement agent if the broker believes there are any errors or omissions on the statement. If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.